Are you thinking of owning your dream homes? EJ Investment is here for you. Secure our quality bungalows with 2, 3 or 4 bedrooms, or our story buildings 3 or 4 to 5 bedrooms at very affordable prices with flexible payment plans at our Sanyang Seaview Estate, where you can enjoy the cool breeze with modern infrastructure such as tar roads, covered drainage system, modern electrification with street lights, gated entrance with security posts, and social amenities such as gas station, shopping mall, medical clinic, park, schools, children daycare, and a lot more. Our dedicated team of professionals will keep the estate clean at all times, provide security and patrol team within the estate premises, install latest technologies such as CCTV, Wi-Fi, home network installation, solar panel, and power backup system. Also, check out for our additional home facilities and interior design service such as premium tiling, wall plaster, home landscape, fingerprint home lock, and a lot more. Visit our office at Senegambia Kololi Highway and get a free site visit tour, or contact us on 4464838. WhatsApp us on 3259220. Or you can visit our Facebook page or Instagram on EJ Investments. EJ Investments, we are first in properties.
Islamic microfinance is becoming an increasingly popular mechanism for poverty alleviation, especially for developing countries around the world. This microfinance service adheres to the principles of Islam as a form of social responsibility. Yona Islamic Microfinance is the Islamic microfinance of choice in the Gambia, trustworthy and reliable. At Yona Islamic Microfinance, we provide savings products, current accounts, financing products in conformity with Islam. In addition, Yona Islamic Microfinance also offers local and international remittances, takaful fund, management of zakat, management of awqaf, trading and investment, and building of strategic partnerships to bring financial services to the doorstep of the poor with donor projects, madrasas, youth organizations, women groups, and farmer organizations. Make a choice with Yona Islamic Microfinance today. For more information on Yona Islamic Microfinance, call 377-2151 or 9832-151, or visit Yona head office at Tipa Garage, Bakote, or visit any Yona branch located countrywide near you.
Proceed with the case before us. We have the applicant to my left, and that's the respondent. Okay, the applicants are to my right, and the respondent to my left. Their names already announced. Just an announcement we wanted to make before we start. Counsel for the applicants, the respondents, will be given 25 minutes each to make their submissions. So how you proceed with the 25 minutes is left to you. That is something you will have to decide. And after your submissions, you will be invited to make your rebuttals. And you have 5 minutes each. So in essence, we have a total of about 1 hour, 25 minutes. For the applicants, 25 minutes, for the respondents and reporters, applicants 25 minutes, and respondents 5 minutes. So thank you, counsel, for the applicant. We can start if you're ready to proceed. Thank you very much.
May it please this Honorable Court, I am Ebenezer Brown, counsel for the applicants in the case of the Platform for the Rights of Migrant Workers versus the Republic of Cairo. Your Excellencies, if it pleases this Honorable Court, in the space of 11 minutes, I'll be addressing this Honorable Court on the preliminary issues, being jurisdiction as well as admissibility. Your Excellencies, as well as issue 2. Your Excellencies, my co-counsel Mohammed Sise will as well address this Honorable Court on issues 1, 3, and 4, respectively. If it pleases this Honorable Court, Your Excellencies, we are here today due to the violations of rights protected by the African Charter, rights in which Your Excellencies are enshrined within all the relevant human rights instruments that has been ratified by the State of Cairo, pursuant to paragraph 8 of the factual records. Your Excellencies, these violations have been occurred on the people of Nungu, who come from the state of Cabo, Your Excellencies. Your Excellencies, the Nungu people are known to be peaceful people as well as law-abiding people. However, in the eyes of the respondent and the state of Cairo, Your Excellencies, the Nungu people's only crime, Your Excellencies, was seeking better economic opportunities as well as a better livelihood, following the fact that their homes and their farmlands were taken away from them due to the mining corporation and the mining activities of the state of Cairo companies. Your Excellencies, the state of Cairo has failed in its obligation pursuant to Article 1 and 2 of the African Charter to protect the fundamental rights that are within the African Charter. Furthermore, Your Excellencies, it is clear within the factual records that the people of Nungu, in search for a better economic and livelihood, Your Excellencies, were subject to detention and arrest and detention, and were kept in inhumane and degrading conditions. It is due to these violations of the African Charter, Your Excellencies, that we invoke this Honorable Court's jurisdiction pursuant to Article 3 of the Protocol, Your Excellencies, which gives this Honorable Court jurisdiction to interpret the African Charter as well as other human rights instruments. Your Excellencies, with regards to jurisdiction, Your Excellencies, we submit, Your Excellencies, that the applicants in this regard, the Platform for the Rights of Migrant Workers, have satisfied the standing requirements before the African Commission due to the fact that pursuant to paragraph 25 of the factual records, the Platform for the Rights of Migrant Workers does indeed have observer status before the African Commission. Furthermore, Your Excellencies, with regards to jurisdiction, it is clear in the case of Konate versus Burkina Faso, in which this Honorable Court decided that there must be certain jurisdictional requirements that must be satisfied before this Honorable Court seizes itself of any application. Your Excellencies, these requirements would involve personal, territorial, material, as well as temporal jurisdiction. Your Excellencies, it is our submission that this Honorable Court has all 4 forms of jurisdiction, pursuant to the fact that the violations occurred within the state of Cairo after they ratified the Charter and Protocol, and rights are protected and enshrined and guaranteed within the African Charter. Your Excellencies, in the case of Peter Chacha versus Tanzania before this Honorable Court, this court stated that alleged violations enshrined within the African Charter, as well as other human rights instruments, the court can exercise its jurisdiction. Your Excellencies, with regards to personal jurisdiction, Your Excellencies, there seems to be a contention. However, I avert this Honorable Court's mind to paragraph 9, wherein, Your Excellencies, the state of Cairo withdrew its declaration of the protocol. Your Excellencies, this withdrawal pursuant to Article 34, paragraph 6 or clause 6 of the protocol, Your Excellencies, would allow individuals as well as non-governmental organizations to file applications before this Honorable Court. However, Your Excellencies, it was a submission that whilst that is so, such is not sacrosanct, Your Excellencies, as this Honorable Court's jurisdiction is rich in the case of Victor Umoza versus Rwanda, especially in this Honorable Court's most recent judgment in Yusuf Hassani versus Tanzania. This court stated that states may withdraw their declarations. However, Your Excellencies, this right is not absolute, as the declaration, Your Excellencies, will create third-party legal rights, in this case, Your Excellencies, individuals as well as non-governmental organizations, which will need some legal certainty. Your Excellencies, it is our submission, and we cite the case of Andrew Ambrose versus Tanzania, where this Honorable Court stated, Your Excellencies, that a withdrawal or a unilateral withdrawal of a declaration would not have retroactive effect on the applications made before the effect of withdrawals or new cases. Your Excellencies, the court further asserted, Your Excellencies, that there must be a 12-month period before a withdrawal of any state party is effected. And the rationale behind this, Your Excellencies, is to avoid the abrupt suspension of rights, Your Excellencies, which will emanate from the legal declaration. Your Excellencies, the applicants in this regard, the respondents and the State of Cayo in this regard deposited their withdrawal on the 16th of July 2021, and based on the reasoning of the court in Victoire Umuhoza versus Tanzania, such withdrawal will be effective on the 16th of July 2022. Your Excellencies, the applicants in this regard have submitted the application.
I want to understand your argument. Are you saying a withdrawal is impossible, shouldn't be permitted at all? Or you say, even if permitted, after withdrawal, you still continue to be bound by provisions of the Charter for a period of what, 12 months? I believe the one that distinction made.
Much obliged, Your Excellencies. I do indeed understand your concern with regards to withdrawal. However, Your Excellencies, due to the fact that this is a unilateral declaration, states indeed, due to consent, have the right to withdraw from unilateral declarations. However, Your Excellencies, the principle of withdrawal, as stated in the court of Victoire Umuhoza versus Rwanda, Your Excellencies, that such would not be absolute, as it is subject to, it needs a 12-month period before there is effect. And the rationale that was stated before the court is to not permit the abrupt suspension of rights or the violation of human rights before individuals.
I just want you to be a bit clear. When you say it's not absolute, what do you mean?
Yeah. Much obliged, Your Excellencies. While this is so, the withdrawal is not unconditional, as it requires a 12-month period before the effect of the withdrawal is made. Your Excellencies, as I was stating, if I have answered your question, the State of Cayo had deposited their article of withdrawal on the 16th of July 2021, which would be effective based on the reasoning of the court in Andrew Ambrose versus Tanzania on the 16th of July 2022. Your Excellencies, the application of the applicants was filed on 10 September 2029, which was well before the withdrawal was effective or was deposited. Thus, Your Excellencies, we submit that this Honorable Court does indeed have jurisdiction to determine this honorable case.
Counsel, if I may ask, one of the instruments you refer to is the ECOWAS protocol relating to free movement of persons, residents, and establishments. Do you think this court has the jurisdiction to apply this instrument?
Much obliged, Your Excellency. I do understand your concern with regards to the ECOWAS principle. However, Your Excellencies, based on Article 3 of the protocol that establishes this Honorable Court, this court has the power, Your Excellency, to interpret human rights instruments as well as the instrument of the ECOWAS treaty, Your Excellency.
Are you aware of any case in which the court has applied an ECOWAS instrument in a court established by the EU?
Much obliged, Your Excellency. As at now, the applicants do not have any case which the ECOWAS treaty was applied. However, Your Excellencies, as an alternative, the applicants in this regard will still stick with the case of Andrew Ambrose versus Tanzania, where the Honorable Court stated that a withdrawal will not take effect unless a 12-month period is satisfied. Your Excellencies, moving on to the issue of admissibility, Your Excellencies, it is clear that the African Charter, pursuant to Article 56, clauses 1 to 7, as well as Article 6, paragraph 2 of the protocol, sets certain requirements which must be satisfied before this Honorable Court can seize itself of any application. Furthermore, Your Excellencies, it is our submission as applicants that the applicants have satisfied Article 6, paragraphs 1 to 4, as well as 6 to 7, which would deal with, Your Excellencies, disparaging languages, as well as mass media. However, Your Excellencies, with regard to Article 56, paragraph 5 of the African Charter, Your Excellencies, which deal with local remedies, which have to be exhausted, Your Excellencies, is our submission, Your Excellencies, that the applicants in this regard are exempted from local remedies. Your Excellencies, in the case of Jawar versus Gambia, before the African Commission, it was stated that the rationale of local exertion of local remedies would be to allow the state to avail itself and the opportunity to judicially remedy issues within their jurisdiction. However, Your Excellencies, the court further asserted in this case, Your Excellencies, that the extraction of local remedies is not sacrosanct and would be subject to subjections. Your Excellency, such subjections would be if local remedies are not available, insufficient, and ineffective. It is our submission today, Your Excellencies, that in this instant case, Your Excellencies, the local remedies that are provided by the judicial system of the State of Cayo are unavailable, and thus, Your Excellencies, will exempt the applicants in this regard from exhausting local remedies. Your Excellencies, in the case of Konate, Burkina Faso, this Honorable Court stated that a remedy is available when the applicant can pursue itself or the case without any impediment, when it is effective as it offers a prospect of success, and sufficient if it is capable, Your Excellencies, of addressing the claim. Your Excellencies, it is our submission that the remedies in the state of Kayo are unavailable due to the fact that there is an impediment. Your Excellencies, I urge this Honorable Court to avert its mind to paragraph 20 as well as paragraph 25 of the factual records, where the migrants in this regard for the Nungu tribe have been in detention for a period of 2 years. Your Excellencies, Section 37 of the Kayo Constitution further does not permit victims who are actual popularis, and thus, Your Excellencies, due to the fact that the migrants in this regard are in detention facilities, this itself, Your Excellencies, serves as an impediment which will not allow the migrant workers, Your Excellencies, to exhaust local remedies, and thus it is our submission, Your Excellencies, that local remedies in this regard are not available.
Are you saying the only way to proceed is for the migrants to appear in court, by themselves? Is it not possible for them to instruct a lawyer to file a case on their behalf?
Much obliged, Your Excellencies. Your Excellency, I do understand your concern with regard to lawyers filing cases on behalf of the applicants or the migrant workers. However, Your Excellencies, I urge this Honorable Court to avert its mind to the fact that in this regard, the Muminatu, Your Excellencies, had filed a habeas corpus before the courts of Kayo. However, Your Excellencies, due to the fact that Section 37, Your Excellencies, doesn't allow actual popularis, Your Excellencies, thus it itself, Your Excellencies, is an impediment, considering the circumstances and the conditions in which Muminatu herself and other migrant workers are kept in detention. Your Excellencies, moving on, Your Excellency, it is clear that in the case of Inter-Rights versus Mauritania, the African Commission, Your Excellencies, and we cite the African Commission cases pursuant to Article 2 of the protocol that establishes this Honorable Court, due to the fact that the African Commission and the African Court work together in order to promote and guarantee fundamental human rights within the African human rights system. Your Excellencies, in the case of Inter-Rights versus Mauritania, it was stated that remedies to be exhausted are those...
Counsel, the time is up. We'll give you a minute to round up.
Much obliged, Your Excellencies. I will just address this Honorable Court on issue 2, if I may be of no further use on admissibility.
You have a minute to do that.
Much obliged. Your Excellencies, Article 2 of the African Charter provides for the enjoyment of fundamental human rights and freedoms, and such should not be restricted on any form of distinction to race, nationality, or status. Your Excellencies, pursuant to paragraph 14 of the factual records, it is clear that the state of Kayo had an initial minimum wage act, which, Your Excellencies, applied to everybody and every citizen or non-national within the state of Kayo. However, Your Excellencies, pursuant to paragraph 15 of the factual records, it is clear that the state of Kayo had amended its act and, Your Excellencies, removed non-Kayo nationals from the purview of the act. Your Excellencies, this is in fact discrimination pursuant to the reasoning of the Honorable Court in the case of the African Commission versus Kenya, where this Honorable Court reasoned that discrimination would be the distinction on exclusion or differential treatment of that is directly or indirectly prohibiting a right. Much obliged, Your Excellencies, if this Honorable Court pleases.
Thank you. We've heard you, friends. So we will hear from your co-counsel.
Thank you, Your Excellencies. May it please this Honorable Court, as already introduced by my co-counsel, Mr. Ebenezer Brown, I am Mohamed Sise, and together with him, I appear on behalf of the applicant. Your Excellencies, having had my co-counsel extensively address this Honorable Court on the preliminary issues, as well as issue 2, with this Honorable Court's permission, I shall be continuing the applicant's submission on issues 1, 3, and 4, respectively, after which, if this Honorable Court so permits, I shall put forward the prayers sought by the applicant before this Honorable Court. Your Excellencies, with respect to issue 1, which relates to the continued detention of the vulnerable migrants together with their children in undignifying detention facilities with the poorest of sanitary conditions, the applicant submits that not only is the migrants' right to liberty and security of person violated, but their right to dignity is as well violated. Your Excellencies, it is the applicant's submission that the continued detention of Mominatu, Enzo, Django, and all the similarly placed migrants violates Article 16, paragraphs 1 and 4 of the International Convention on the Rights of Migrants, as well as Article 6 of the African Charter. Your Excellencies, this Honorable Court, in the case of the African Commission versus Libya, confirmed that deprivation of liberty, regardless of its form, is only permitted when it is in conformity with the procedures established by domestic legislation, which itself has to be consistent with international human rights standards. In this case, Your Excellencies, The arrest and subsequent detention of the Nungu workers was neither authorized nor is it in accordance with any existing legislation in Cairo, including the 1975 Immigration Act of Cairo. Your Excellencies, in paragraph 20 of the compromise, the Director General of Immigration, in ordering the arrest and detention of the Nungu workers, purportedly and misleadingly relied on Section 25 of the Immigration Act. However, Your Excellencies, the provision of the said section does not confer on the Director General of Immigration any such powers. The applicant refers this Honorable Court to paragraph 12 of the compromise, where it is clearly stated that Section 25 of the Immigration Act confers on the Director General of Immigration powers of revocation and not any such powers of detention. Therefore, Your Excellencies, bearing in mind the fact that such an arrest and detention is not based on any law, the applicant submits that this is a violation of the migrants' right to liberty and security of persons guaranteed under Article 16, paragraphs 1 and 4 of the International Convention on the Rights of Migrants, as well as Article 6 of the African Charter. Additionally, Your Excellencies, the applicant submits that the continued detention of the
Counsel, may I please ask this question? You highlighted the fact that the Director General doesn't have the power to detain but prior to revoke, is that correct? But apparently, if revocation actually happes, so does that not make the individual to be illegal in that particular country and thereby subsequently violating the laws of the country, and then therefore detention will definitely be the end result of the revocation and illegality?
Your Excellencies, the applicant refers this Honorable Court to paragraph 12 of the compromise, where it is clearly stated that the Director General, even though has the power of revocation, but such a power can only be exercised where a migrant is convicted of an offense under the 1975 Immigration Act, a thing that has never happened. Therefore, Your Excellencies, the Director General of Immigration acted ultra vires of his powers.
Also, if I may follow up on that, you're referring to the Immigration Act of Cairo. Are you asking this court to interpret that act? Does this court have the power to look into that act?
Your Excellencies, the effect of my reference to the Immigration Act of Cairo is to show this Honorable Court that the respondent did not even comply with its own domestic laws, and such non-compliance, Your Excellencies, makes the arrest and detention of the Nungu workers a violation of their right to liberty and security of persons as guaranteed in the International Convention on the Rights of Migrants, as well as the African Charter. Your Excellencies, additionally, the applicant submits that the continued detention of the migrants is a violation of their right to be promptly brought before a competent judicial authority or a judge as guaranteed under Article 14 of the International Covenant on Civil and Political Rights. Your Excellencies, in the case of the African Commission versus Libya, this Honorable Court at paragraph 91 noted that every individual arrested should be brought before a competent judicial authority with minimum delay and be tried within a reasonable time or be set free. Your Excellencies, as...
So you just referred us to the ICCPR, which is a UN treaty. This is an African court. And you say we have jurisdiction looking to violations of the UN treaty.
Your Excellencies, pursuant to Article 3 of the Court Protocol, this Honorable Court shall have the power to interpret and apply all treaties, the African Charter, the Court Protocol, and all other material instruments ratified by the respondent state. And pursuant to paragraphs 9 and 10 of the compromise, the respondent state, Your Excellencies, has ratified the International Covenant on Civil and Political Rights. Thus, this Honorable Court does have the jurisdiction to apply this Honorable Court, to interpret and apply the ICCPR. Your Excellencies, as I was saying, in the instant case, the applicant's continued detention is a violation of their right to be promptly brought before a competent judicial authority. This Honorable Court, in the case of the African Commission and Libya, noted that every individual arrested should be brought with minimum delay before a competent judicial authority and should, within a reasonable time, be tried or be set free. As indicated in paragraph 20, Your Excellencies, the Nungu workers have been in detention since the 25th of June, 2010, and have not been released as of the 10th of December 2021, Your Excellencies, for almost 3 years. By this, Your Excellencies, the applicant submits that the respondent state has violated the Nungu workers' right to be brought with minimum delay before a competent judicial authority. Your Excellencies, furthermore, according to paragraph 20 of the compromise, scores of migrants were compressed in undignifying detention facilities with only 2 toilets. in the most horrible conditions, Your Excellencies. The applicant submits that this is a violation of the Nungu workers' right to dignity as guaranteed under Article 17 of the International Convention on the Rights of Migrants. Your Excellencies, according to the UN Body of Principles for the Protection of All Persons under any form of detention or imprisonment, migrant workers under detention should be treated with dignity and with utmost respect for their inherent dignity. Your Excellencies, similarly, the UN Special Rapporteur on the Human Rights of Migrants, George Bostman, in his 2010 report, indicated that migration-related detention centers should not bear similarities with prison-like facilities.
But then since there have been prolonged detention, have you tried any local, to secure local redress at the local level? Perhaps maybe plan habeas corpus application?
Very well, Your Excellencies. The applicant refers this Honorable Court to paragraph 23 of the compromise, where it's clearly indicated that one of the migrants, Muminatu, through her lawyer, Barrister Moses, tried approaching the High Court of Cairo for redress. But Your Excellencies, as highlighted by my co-counsel, the court declined jurisdiction on the said issue. Your Excellencies,
you made reference to some UN principles, and you also referred to something said by UN Special Rapporteur. Can you explain what the legal status of those principles or the statement you just read out? What is the legal status? Would you say force of law, same level as the treaties you referred to earlier, or it's something different?
Your Excellencies, the applicant cites these principles as persuasive, for persuasive reasons, pursuant to Article 61 of the African Charter. Furthermore, Your Excellencies, it is indicated that children were alongside adult migrants detained. The applicant submits that this is a flagrant violation of Article 37 of the Convention on the Rights of the Child, which provides that detention of children should only be a measure of last resort and for the shortest possible time. Your Excellencies, in this instant case, the detention of the children was neither a measure of last resort, nor was it for the shortest possible time. The children have been in detention since the 25th of June 2019, and the respondent state cannot show that this was a measure of last resort, as it had so many alternatives available to it, such as home curfew and other non-custodial measures like electronic tagging, release on bail, release on surety, but the respondent, Your Excellencies, never considered any of that. Instead, Your Excellencies, the respondent preferred the detention of children that should have been in the classroom for almost 3 years. Your Excellencies, moving on to issue 2, the applicant submits that the respondent states disallowance of the Nungu workers the right to form a trade union is a flagrant violation of Article 10 of the African Charter, which provides that every individual shall have the right to free association, as well as Article 23 of the International Convention on the Rights of Migrants, which provides that migrant workers and members of their families shall have the right to freely join any trade union. Your Excellencies, in the Tanganyika Law Society and others, this Honorable Court noted that the freedom of association is a right that should be enjoyed by everyone without undue or unnecessary impediment. Your Excellencies, the applicant does understand that the right is subject to some limitations. However, Your Excellencies, the restrictions on the right have to be prescribed by law and have to be necessary as well. Your Excellencies, in the instant case, the restrictions on the right was neither prescribed by law nor was it necessary, Your Excellencies. Pursuant to paragraph 16 of the factual report, Your Excellencies, the only reason advanced by the Registrar of Trade Union for the denial of the Nungu workers the right to form a trade union was that non-nationals are not allowed to form a trade union in the state of Cairo. Your Excellencies, the applicant submits that the denial of the Nungu workers the right to form a trade union on the single premise of nationality is in itself discriminatory and, of course, a violation of Article 2 of the African...
Was there also not the claim that the registration was purely based on a tribal political party?
Your Excellencies, the applicant considers this to be...
was that also not a ground for the refusal?
Yes, Your Excellencies, it was.
Can you address us regarding that claim?
Pursuant to...
The claim that you were actually forming a tribal political party?
According to Article 16, Your Excellencies, the Registrar of Trade Unions made without any proof, an allegation that the Nungu workers were desirous of forming a tribal political party. But Your Excellencies, this in itself does not hold water. How can people that left their states of origin in search of greener pastures be forming a political party in a foreign land, Your Excellency? Your Excellency, having said that, this honorable, moving on to the issue of nationality, the applicant submits that the denial of the Nungu workers the right to form a trade union on the single premise of their nationality is in itself discriminatory and a violation of Article 2 of the African Charter. This is so because a sort of a preferential treatment is accorded to nationals over non-nationals. And this honorable court, Your Excellencies, in the case of the African Commission versus Libya, noted that preferential treatment becomes discrimination.
Counsel, your time is up. We'll give you a minute around. 1 minute.
Okay. Thank you, Your Excellency. A preferential treatment becomes discrimination when it does not have a reasonable justification. And in this case, Your Excellency, the respondent cannot advance any justification or any reason that justifies the denial of the Nungu workers the right to form a trade union on the basis of their nationality. Your Excellency, moving on to issue 3, which relates to the proposed mass expulsion, the applicant submits that the respondent state has violated or has been in breach of its international obligation in that the proposed expulsion is not in compliance with any existing law in Kerr and the fact that it is intended to be collective. Your Excellencies, according to Article 12, Paragraph 4 of the African Charter, as well as Article 22, Paragraph 1 of the International Convention on the Rights of Migrants, non-nationals legally admitted into the territory of the state can only be expelled pursuant to a decision taken by a competent authority. Much obliged, Your Excellency.
Thank you, Mr. President. Your Excellencies, may it please this honorable court, I am Amikola Sar, and I appear on behalf of the respondent, the Republic of Kerr, together with my co-counsel, Mr. Omar Diva. Though in an unfortunate circumstance, but it's a pleasure for us to be before the African Court on Human and People's Rights in a matter brought forth by the Platform for the Rights of Migrant Workers against a state known for its peace and stability, credited mainly to its homogeneity. In the next 11 minutes, I shall be addressing this honorable court on the preliminary issues, as well as the merits of Claims 1, whilst my co-counsel will highlight the respondent's submission on the merits of Claims 2, 3, and 4. The outline of my submission would be briefly on jurisdiction and standing, 2, on the elaborative deliberation on the admissibility of the case, and 3, which is the, with regards to merits 1, which deals with the continued detention of Muminatu and her 2 children, as well as the similarly placed migrant workers in detention centers in Kerr, which, Your Excellencies, the applicant purported to say that have been a violation of the various international human rights instruments which we have ratified as a state, including the International Convention on the Protection of All Rights of Migrant Workers and members of their families, herein referred to as the ICRMW. Your Excellencies, before this honorable court today is a case filed against a state that has won the hearts of many. Your Excellencies, this case is filed against a state that has over the years promoted and protected human rights and also peace and stability. A country that has opened its labor force, Your Excellencies, to not just foreigners but also migrant workers by providing shelter as well as employment opportunities. Your Excellencies, a country that has over the years, Your Excellencies, lost itself in the services of people, irrespective of their background. Your Excellencies, this is the mantra for which we are known for as a respondent state, and until today, I'm making my opening statement with regard to the case from the respondent's point of view.
Remember, we have, I think, about 10 minutes left.
Thank you, Your Excellencies. Much obliged. Your Excellencies, we are here today ready more than ever to protect and also reaffirm to this honorable court our commitment for the protection and promotion of human rights. On jurisdiction, Your Excellencies, we do not wish to contest on the jurisdiction of the court pursuant to Article 3, Sub 1 of the Protocol to the African Court on Human and People's Rights. Your Excellencies, according to Article 3, Sub 1 of the Protocol to the African Court on Human and People's Rights for the establishment of an African court, Your Excellencies, this honorable court has the jurisdiction to hear this case, Your Excellencies. According to Article 3, Sub 1, Your Excellencies, this Honorable Court has the jurisdiction to hear and entertain all matters regarding the interpretation and application of the Charter, as well as other human rights instruments. According to Article 5, Sub 3 of the Protocol, Your Excellencies, this Honorable Court can entitle relevant non-governmental organizations with observer status to approach the Honorable Court or the Commission, Your Excellencies, to institute cases directly before it. However, we have deposited an instrument for withdrawal, and that, Your Excellencies, will no longer give this Honorable Court the jurisdiction, and in that instance, I mean will not give the applicant in this case the local standi in order to bring forth a case before this Honorable Court. Like I said, we have deposited an instrument of withdrawal on the 16th of July 2021, Your Excellencies, and this intention was to prevent the complaint of procedure by claims that are brought forth by criminals and foreigners. Your Excellencies, we are aware of the Ingabere Omohozwa Victorua case cited by the applicant in this case, Your Excellencies, but we love to avert this Honorable Court's mind to the fact that this Honorable Court does not, Your Excellency, does not, I repeat, is not a subject of stare decisis, and the fact that this Honorable Court should disregard its decision on that matter. It is important to note that under international law, Your Excellencies,
if I may interrupt you one bit, you have said that this Honorable Court should not take applications from criminals and foreigners. Are you equating foreigners with criminals? Secondly, are you saying foreigners who are legally in your state should not have the right of access to this court?
Thank you very much, Your Excellencies, much obliged. That actually was cited with regard to the withdrawal we have deposited, Your Excellencies. And with regard to that, I actually averted this court's mind to the reason why the withdrawal was made. And the fact that the applicant had argued that such withdrawal cannot affect already pending cases, Your Excellencies. But the fact that the case is already pending, we would like to say that this Honorable Court should not regard its decision with regard to the case cited by the applicants in this case regarding the withdrawal.
Would you be able to supply any legal reason why the court should depart from its decision in the other case?
Thank you very much, Your Excellencies. Much obliged. Like I said, we humbly request that this Honorable Court should depart from that, and that is because of the fact that this Honorable Court is not guided by the principle of stare decisis, and it is not in any way guided by the principles of precedence, Your Excellency. So it can, in that regard.
Let me hear. I want to refer you to a real ruling of this court dated the 5th of September 2016. Specifically, I'm referring you, is the Ingabire case you referred to, and I'm specifically referring you to paragraph 63. And in paragraph 63, this court cited with approval a judgment of the Inter-American Court. This is what it says. It's a case against Peru. A unilateral action by a state cannot divest an international court of jurisdiction it has already asserted, where a state is allowed to withdraw its recognition of the court's contentious jurisdiction. Formal notification would have to be given 1 year before the withdrawal could take effect for the sake of judicial security and continuity.
Thank you very much, Your Excellencies. Much obliged. The applicant agrees that the withdrawal cannot affect already pending cases, and the case you cited with regard to the Peru case, Your Excellencies, gives a 1 year prior notice which shall be given, Your Excellencies. It is a submission that such 1 year prior notice that needs to be given by a respondent state, Your Excellencies, is unreasonable. And the fact that this case that the applicants have filed before this Honorable Court have been dragged for way too long, Your Excellencies.
What makes it unreasonable?
Thank you very much, Your Excellencies. Much obliged. Like I said, we humbly request that this Honorable Court depart from such decision, Your Excellencies, considering the fact that the case of the applicant has been dragged.
My problem is, I've heard your point. You want this court to depart. Why do you want us to do so? Give us reasons. We want the court to depart based on X, Y, Z. I haven't heard you giving us any reason why you think we should depart from the ruling in particular, the one I just read out to you.
Thank you very much, Your Excellencies. The declaration we have made under Article 34, which warrants the withdrawal that we are making, Your Excellencies, like I said, this is a political commitment, Your Excellencies. And the fact that we have a discretion at this point to withdraw, Your Excellencies, and that such laws that have been provided for regarding the 1 year prior notice, Your Excellencies, is unreasonable in this instance. And the fact that the case, like I said, have been filed for way too long, and the fact that if it were of that importance to the applicant in this case, then they could have in other ways bring forth better ways of adjudicating the case, but instead they have dragged the case have been dragged for way too long, and it is quite unreasonable in that instance for us to for us to give a 1 year prior notice in this instance. Therefore, it will in another way, the court should grant that such withdrawal be granted on the basis that we are currently in a very, very, very fragile state as a country, and that it will delay our plans of hosting the Cup of Nations, as well as the fact that this could render our country unstable.
You had mentioned that belong. What has that got to do with you fulfilling the 12 months requirement?
After the case was already filed before this honorable court, then it would quite be unreasonable if we have to send a 1 year prior notice when a case is already filed. What we are asking for as a respondent state is that such 1 year prior notice that is requested, that is required for us to bring forth before such withdrawal be affected, be reconsidered in a sense that a shorter notice be given before this honorable court can grant the withdrawal. Your Excellencies, if there are no further questions, I'd love to move to admissibility.
Go ahead, please.
Thank you very much, Your Excellencies. On Article 6, Sub 2 of the Protocol, Your Excellencies, this honorable court shall rule on admissibility of a case, bring into consideration the provisions of Article 56 of the African Charter, also known as the Banjul Charter. Your Excellencies, the applicant have considered that they are required to exhaust local remedies, and that, Your Excellencies, is provided for under Article 56 sub 5 of the African Charter. Your Excellencies, on case-to-case basis, on the first issue, which is the continued detention of Muminatu, her 2 children, and others, the similarly placed migrant workers, Your Excellencies, the applicants have failed to exhaust local remedies in that issue. The fact that Muminatu have filed through her lawyer, Barrister Moses, in bringing a case for her release, Your Excellencies. The case was actually did not proceed because of the fact that Barrister Moses did not have the standing, Your Excellencies. But he filed out of time in the Court of Appeal, and he was not granted leave of court, Your Excellencies. And that, Your Excellencies, in this regard, means that the applicant did not exhaust the local remedies which were available, efficient, and sufficient, provided for by the respondent state.
Are you telling this court that the applicant should continue to lavish in the unfavorable condition just because they cannot get access to the local remedies? In as much as we've heard from the applicants that they tried to access the local courts, but they couldn't do so. It's not applicable, or it's not accessible to them. So are you telling the court that we shouldn't hear this case because they have not exhausted the local remedies?
Thank you very much, Your Excellencies. In the case of Jakiti versus Mali, Your Excellencies, this honorable court delivered that the exhaustion of local remedies is an exigency of international law and not a matter of choice. Therefore, this honorable court would have to rule in favor of the...
Your time is up. Because you were interrupted when you started, we will give you 2 minutes to round up.
Thank you very much, Your
2
Excellencies.
minutes, please.
Your Excellencies, on the second issue, which is with regards to the discriminatory nature, the alleged discriminatory nature of the amendment that was made by the respondent state, the alleged discriminatory nature of the Minimum Wage Act, Your Excellencies, the applicant under paragraph 21 of the compromise did not further pursue the case, and that, Your Excellencies, the case was referred to the Constitutional Court, which was provided for to hear cases of such issues, Your Excellencies. And on issue 3, Your Excellencies, which is with regard to the trade union, the denial for the registration of the trade union, the applicants have failed woefully in exhausting local remedies because such matter was in fact not litigated, Your Excellency. And on the fourth issue, Your Excellencies, When the matter was taken before the High Court, Your Excellencies, there was a restraining order that has been granted by the High Court in Cairo. And this, Your Excellency, is a reaffirmation that we as a respondent state have a very trustworthy judicial system in which the respondent could have explored in order to exhaust these local remedies. And on issue one, Your Excellency, since I don't have much time, following the chain of events, Your Excellency, which warranted the arrest and detention of Muminatu, her 2 children, as well as the similarly praised migrant workers, Your Excellencies, we deny the allegations that have been put forward by the applicants in this case, and that we have not failed in our obligations as a state in order to fulfill the requirements of the international instruments which we have ratified as a state, including the ICRMW. Your Excellency, as part of our efforts to regularize the system in the system as well as the immigration laws in Cairo, we made a pronouncement, Your Excellencies, through the Director General of Immigration that, and this is provided for under paragraph 20 of the compromise, that in fact we gave them 14 days grace period, Your Excellency, for them to regularize their status or their stay in the state of Cairo. But they have failed.
Your time is up. I'm afraid we'll have to leave you now.
Thank you. Thank you.
Thank you very much, Mr. President, Your Excellencies. Good afternoon. I am Omar Diwa, Co-Counsel for the respondent state. Mr. President and Your Excellencies, before you today appears a respondent state whose judicial governance and other systems, including its law, code, and other systems, do not remotely close to reflecting the catalog of allegations made against it by the applicants. Your Excellencies, before you today appears a court that has opened up its economic industries and also its labor market to welcome influx of migrants in its country with open arms as they seek opportunities for better lives. Your Excellencies, this has put our state in a more complex and volatile situation as we are faced with economic challenges, political and other challenges that has threatened the life of our country. However, Your Excellency, most importantly, before you is a state that has provided the applicants before this court decent jobs, decent wages, food, shelter, and other services. This has been the true reflection of our character as a state, and we are forever grateful for remaining through our international obligations as a state. This is a unique glory we shall ever continue to live for and cherish. Distinctly, Your Excellencies, the coming in of migrant workers have threatened our economic situation, and this is the reason we are before this honorable court, Your Excellencies. Having said that, Your Excellency, the outline of my submission is as follows. I will submit on issue 2, which deals with the amendment of the Minimum Wage Act 2010 of the respondent state. I would also submit on issue 3, which deals with the denial of the application for the registration of a trade union by the Director General, by the Registrar of Trade Unions in the respondent state. Thereafter, I will submit on issue 4, which deals with the proposed expulsion of the detained migrant workers from and by the respondent state. And then I will offer our prayers before this honorable court. Your Excellencies, without any question, I would move to make my submission on issue 1. Thank you very much, Your Excellency. The rights in concern with respect to issue 2, Your Excellency, are the right to equality, the right to work under satisfactory and equitable working conditions. Your Excellency, the respondent state hereby respectfully submits that it is indeed by practice and law conscious of its international duties to ensure the fulfillment and realization of this right as a state signatory to the African Charter, which under Article 15 provides for the right to work and the right for equal pay. The Migration for Employment Convention, which equally under Article 6.1 frowns upon discrimination against migrant workers, as well as the International Covenant on Economic, Social, and Cultural Rights, which under Article 6 enjoins the respondent state to recognize and fulfill the right to work. Your Excellency, in demonstrating our readiness to ensure the fulfillment and enjoyment of this right, as a state with dualist leaning, we enacted a Minimum Wage Act in 2010 to domesticate this right for its enjoyment by our nationals and non-nationals residing in our country. This has been affirmed in. However, Your Excellency, these rights are not absolute under international law, hence they can be reasonably limited or even derogated in accordance with the United Nations human rights standards, which include the principle of reasonableness, objectiveness, proportionality, if the aim indeed is to achieve a legitimate objective, Your Excellency. This has been affirmed, Your Excellency, in paragraph 1 of General Comment number 18 to the ICCPR, in which the United Nations Human Rights Commission stated that not every differentiation of treatment will constitute discrimination if the criteria for such differentiation are reasonable and objective, and if the aim is to achieve a purpose which is legitimate under the Universal Declaration. Your Excellency, the bone of contention and the analysis must be within the context of reasonableness, objectiveness, and also proportionality. Your Excellency, given our economic situation. Yes, sir.
Council, you have laid out the three-part test in determining the validity of limitations to rights. And one of the factors you have mentioned is the reasonableness. Don't you think this amendment you have passed is discriminatory to foreign workers? And you know very well that laws that are passed to limit rights must not be discriminatory. How would you respond to that?
Thank you very much, Your Excellency. The respondent has noted your concern over the enactment we have done through our parliament. Your Excellency, to qualify an act, particularly an affirmative action, to be discriminatory, the context of its discrimination or the context of qualifying it to be either discriminatory or not is to look at the general comment made by the United Nations Human Rights Committee in conjunction with the UN Human Rights Standards, which propounded three fundamental principles, including reasonableness, as you have asserted. To justify the principle of reasonableness under this circumstance, Your Excellency, what is reasonable to do as a state is to take an affirmative action to sustain and bring back the life of our economy, to protect our people and our sovereignty as a nation. Your Excellency, this is in line with this standard, and we think we acted reasonable enough by removing non-nationals from under the purview of the Act in order to save the life and sustain in order to save and sustain the life of our economy and to be able to run our state of affairs as a nation. Your Excellency, under the circumstances, also, what is objective?
Just a minute. I just want you to help me understand maybe the distinction. You talked about affirmative action. You talked about restricting the rights, and of course, you also referred us to the three-part, test. But what I'm struggling to understand, restriction as opposed to taking away a right. What did your government do in this particular case? Did you have their rights restricted, or you had their rights taken away, which is way beyond just imposing a restriction?
Thank you very much, Your Excellency. Looking at the general comment made to the to the ICCPR by the United Nations Human Rights Commission, the restriction, the affirmative action may not necessarily only be a restriction, but it can in fact amount to derogation if it is in accordance with the Universal Declaration on Human Rights. Your Excellency, in this case...
Are you saying there was a derogation in this case? And is it possible to derogate from provisions of the African Charter?
Your Excellency, under circumstances, there are clawback laws that protect states in fulfillment of their international obligation, particularly with respect to economic rights. All over the world, Your Excellency, one of the most fundamental instruments that guarantees the enjoyment of economic rights is the International Covenant on Social, Cultural, and Economic, Social, and Cultural Rights, which in fact has provided that states should take affirmative steps to ensure the realization of this right. That goes to show that, Your Excellency, that the enjoyment and fulfillment of this right by state is not an objective to attain in a short spell of time. Instead, it is a process. That is why they imposed a minimum cost standard that states must ensure to fulfill in order to guarantee the economic rights of every person, irrespective of their background. Excellency.
Yeah, so you refer to a minimum cost, and one very important element is non-discrimination. They say you discriminated against them, so it means, there really was no compliance with your commitments under the treaties you ratified.
Yep.
You said minimum core, progressive realization, but that is what is called a minimum core. And one important aspect of that is non-discrimination. So how do you respond to that?
Thank you very much, Your Excellency. The restriction is not going to subject the migrant workers to non-pay at all in our country. Instead, we have just momentarily removed them from under the purview of the Act, which therefore means that they would not be paid in accordance with the Act, but not that they would not be paid entirely for the labor they did for our country. Your Excellency, removing them under the purview of the Act simply implies by all actions that we are not willing any longer, due to our economic situation, to be able to pay them in accordance with the minimum wage that we have in our country, but not necessarily...
My question is, you earlier spoke about Article 15 of the African Charter on Human and People's Rights regarding equal work and equal pay. You mentioned your commitment to make sure you observe these laws. So apparently, if you're now talking about the economy, which would perhaps be the reason as to why you made the amendment, don't you think it will be more effective on the economy to actually make that amendment to be a general amendment and to affect everybody rather than just to affect the new workers?
Your Excellency, thank you very much. The respondent has noted your concern respectfully. The purpose of the amendment is not to lessen our annual expenditure as a state, but it is to ensure that we sustain and keep alive our...
That's my point. My point is, why not make it a general application rather than just targeting foreign nationals? Are you saying it's just sufficient once you target the foreign nationals' wages that will solve your problem? Is that what you're saying?
Thank you very much, Your Excellency. Once again, the respondent has noted your concern respectfully. Like I said, Your Excellency, the purpose of the amendment is not to cut down our expenditure, Your Excellency, but to ensure we take affirmative action that will sustain the life of our economy. And this includes not just lessening our expenditure, but making sure that we institute safeguards that will protect our people. And this will subject, obviously, migrant workers to differential...
I just wanted you to address on the issue regarding why have a specific reduction which affects only a particular group and not make it general, which will probably address the issue of the economy more and better.
Thank you very much, Your Excellency. Once again, the respondent has noted your concern respectfully. The purpose of removing only the migrant workers from under the purview of the Act is to accord our citizens the maximum respect for their economic rights that they deserve. Even though we agree that we are under obligation under Article 15 of the African Charter to ensure the protection and fulfillment of the right to work, Your Excellency, this is not an absolute right, particularly for migrant workers. And therefore, it is in our interest that we treat them differently as non-citizens. And this does not in any way amount to discrimination, as I have highlighted, because it has fallen within the remits of the propounded principles that were affirmed in the General Comment number 18 to the International Covenant on Civil and Political Rights by the United Nations Human Rights Committee. Without question...
Yes, just one question, Council. Are you telling us that when faced with an economic repression, the state has the right to pick and choose on which particular rights to protect and which rights to derogate from? Is that what the state is telling us?
Thank you very much, Your Excellency. The respondent has noted your concern with respect. Your Excellency, all the rights might be involved in this provided that it were wider in scope. However, Your Excellency, in this case, only the economic aspect of their right is in question and contention. Therefore, we have no interest in dealing with other rights, Your Excellency, particularly political and cultural rights.
Your time is up. We will give you 1 minute.
Thank you very much, Your Excellency. Still on this issue, Your Excellency, I would like to draw this, avert the mind of this court on a case that has been cited by the applicants, which is the Kerr African Commission on Human and People's Rights versus Kenya application number 002. Your Excellency, this court is not bound by the principles of state decisis under international law. And therefore, given the eminent peril that our economy is faced with, we therefore plead this honorable court to respectfully move away from the decision it has made because it is not bounded by the principle of state decisis, Your Excellency. Your Excellency, moving to issue 3, Your Excellency, the rights in concern with respect to this issue is the right to free association. Your Excellency, the respondent state as a state signatory, to the African Charter hereby acknowledges that it is indeed under obligation to protect this right. Your Excellency, unarguably, as a state signatory to this, we are also conscious of the role that trade unions play. Your Excellency, trade unions are economic trendsetters that seek to protect the social and economic interests of their membership only. And this is mostly done through protests and unending strikes, Your Excellency. Your Excellency, unarguably, the applicants have evidently...
Please, the time is up. Thank you. We've heard you. We're going to start with the counsel for the applicant. Counsel Brown, you're making the water? Yes. Okay. Please go ahead, you have the floor. You have 5 minutes each.
Your Excellencies, with regards to jurisdiction, the respondents duly stated that the withdrawal doesn't have any effect on Your Excellencies. However, we cite again the case of Ambrose versus Tanzania, where Your Excellencies, withdrawal has no retroactive effect on applicants made before effect of withdrawal or new cases. Furthermore, Your Excellencies, the respondents duly stated that the respondent state of Cairo has not made or violated or its obligations under international law. However, Your Excellencies, pursuant to Article 5 of the African Charter, as well as Article 10 of the International Convention on the Protection of Migrant Workers and their Families, the state of Cairo has the obligation to prevent and guide citizens as well as non-nationals from degrading and humane treatment. However, Your Excellencies, it is clear that pursuant to paragraph 20, the state of Cairo has failed woefully, Your Excellency, in providing sanitary conditions on behalf of the migrants. And in case of Media Rights Agenda versus Nigeria, Your Excellencies, the African Commission asserted that the issue of degrading and inhumane treatment should be read broad in order to protect victims. Furthermore, Your Excellencies, we cite pursuant to Article 60 of the African Charter, drawing inspiration from other cases and other jurisprudence, Your Excellencies. In the case of Floria versus Romania, before the European Commission, court rather, that bad conditions violated the protections from inhumane and degrading conditions. Thus, Your Excellency, it's our submission that the state of Cairo has violated the provisions, especially Article 10 of the International Convention on the Protection of Rights of Migrant Workers. Furthermore, Your Excellencies, with regards to issue 2, Your Excellencies, in the case of Girls Yin and Bosico versus the Dominican Republic, in the present or in front of, before the Inter-American Court of Human and People's Rights, it was stated that the obligation to respect, and I quote, the obligation to respect and ensure the principle of non-discrimination is irrespective of a person's migratory status in a state. And thus, Your Excellencies, the state of Cairo has an obligation to ensure that this fundamental principle to its citizens and to any other non-national on its territory without discrimination to regular or irregular residents. Your Excellency, this is a violation clearly of Article 25 of the International Convention on the Protection of Migrant Workers, which states that all migrant workers are to be treated on an equal footing with nationals regarding remuneration conditions of work. Furthermore, Your Excellencies, with regards to the United Nations International Committee on International Economic and Social Cultural Rights, stated that with regards to removal or in a state of where there's recession, the state must use the least intrusive means or alternatives rather than looking for measures or means of a form of distinction. Furthermore, Your Excellencies, in the case of International Federation of Human Rights, Leagues versus France, the European Committee, Your Excellency, stated that social rights and the court in this regard disregarded the appendix of the European Social Charter, which excludes, Your Excellencies, certain non-nationals from the scope of its treaty. This shows, Your Excellencies, that international law, Your Excellencies, has moved and shifted in protecting the right of non-nationals from distinction and discrimination. Furthermore, Your Excellencies, with regards to the migrant workers and issue 4, Your Excellencies, it is stated in the case of Rado versus Zambia that the African Commission at paragraph 20 asserted that the drafters of the charter believed that mass expulsion presented a social and special threat to human rights. Similarly, Your Excellencies, the United Nations Special Rapporteur, Your Excellencies, Felipe Gonzalez, in the report of 19 May 2021, clearly stated that deportation of migrants cannot be carried out in a summary manner. Your Excellencies, the state of Cairo has failed to look at an individual basis of each migrant, Your Excellencies, and Your Excellency, the proposed expulsion would have amounted to mass expulsion, which is clearly prohibited under Article 22, Your Excellencies, of the ICMRW, which is the protection of migrant workers. Thus, Your Excellencies, it is clear that the state of Cairo has violated its obligation. Your Excellencies, in conclusion, we pray that this Honorable Court considers that it has jurisdiction to hear this case, that the applicants have satisfied the requirements of Article 56 of the African Charter, and on the merits, we humbly pray that the Court rules that the respondent state has violated its international obligations, Your Excellencies, with regards to issues 1, 2, 3, and 4, that the Court orders the respondent state to release and detain migrant workers, and furthermore, that, Your Excellency, that the Court orders or makes a declaration that the respondent state violated and the Minimum Wage Amendment Act was discriminatory. And finally, Your Excellencies, that the Court orders the respondent state to refrain from executing or furthermore any form of mass expulsion, Your Excellencies. If it pleases this Honorable Court, Your Excellencies, this would be the conclusion of rebuttal.
Thank you, Counsel. We will invite the respondent Councillor Debo, you making the rebuttal. Okay, please note that you have 5 minutes.
Thank you very much, Your Excellency. Your Excellency, the respondent state have learned with the submission made by the applicants, labeling the applicants as peaceful agents who only migrated in search of economic opportunities. Your Excellency, we wish to respectfully submit before this honorable court that in fact, the contrary its forces has been stated, Your Excellency. Your Excellency, the applicants before this honorable court are known to be very unpeaceful agents who have run their country into bloody civil war in 1970 as evident in paragraph 2 of the facts of the case. Your Excellency, through this civil war, they have killed their own people on lines of tribe and also religion. Your Excellency, therefore, on this ground of their callousness, Your Excellency, we cannot allow them to register a trade union through which they could hide behind the advocacy for the interests of their people to render our country ungovernable, using indefinite strike and also civil disobedience, as they have already done in accordance with paragraph 22, when we made announcement for them to embark on work, which they refused and then they denied to do so. Your Excellency, grounds of national security and public order are grounds for the legitimate subordination of the right to association and assembly under ICCPR in accordance with Article 22(1), Your Excellency. Your Excellency, the ICCPR, among other human rights instruments that we have ratified, have legitimately provided grounds under which the right to free association can be subordinated, and indeed we acted in good faith by denying them the right to register a trade union in our country, through which they could be potential economic trendsetters in our country by embarking on industrial actions and also civil disobedience. Your Excellency, most horrifically, is the submission made by the First Council on the exhaustion of local remedies, Your Excellency. Your Excellency, the respondent wishes to remind this court the case of Dikiti versus Mali, which they have gratefully and profoundly cited, that this court has reasoned in this case that the exhaustion of local remedy is in fact not a matter of choice, but an exigency under international law that applicants must fulfill before this honorable court can hear their case. Your Excellency, having failed to approach our court with respect to issue 1, which is the detention of their people, having filed out of time by Barrister Moses on their behalf, we therefore feel it necessary that they have not conclusively exhausted local remedies which were available efficiently, effectively, as we have the courts and also the system. In fact, evidence of this is the manifestation that our independent judicial court, which is the High Court, have done by allowing them to file a lawsuit and determining in their favor, thus ordering a restraint order restraining our Director General of Immigration from deporting them. On the issue of deportation, Your Excellency, we want to make it abundantly clear that it is a proposed deportation, and the respondent state has not taken any step to ensure that it is effected. In fact, we are conscious of all the rights that are provided in Article 22 of the Convention of the Right of Migrant Workers and Members of their Family, which has put on blow-by-blow basis procedures and regulations that must be fulfilled for a state to qualify to be able to subject migrant workers to expulsion, be it in mass, be it in refoulement, or be it any other means. We are conscious of all these procedures, and we will follow them accordingly, including the treatment of their cases one by one. Your Excellency, having said all this, I wish to read our prayers before this honorable court for due consideration. Having extensively submitted on the preliminary and substantive issues before this honorable court, we, the respondent state, hereby honorably pray for this court to dismiss the case in accordance with Rule 31(1) of the rules of this court, and also recognize and respect the deposited instrument of withdrawal filed by the Republic of Kerr in our interest and the interest of our people and our sovereignty and our national security. And also to declare the Republic of Kerr that the Republic of Kerr has not violated its international obligation, and also allow the Republic of Kerr to follow due process to expel the illegally resident and ungrateful migrant workers in our country. Thank you very much, Your Excellency. That marks the end of our prayers.
All of you have been fantastic. I hope eventually that you end up as human rights lawyers, and I hope Mr. Diba works for the Gambian government. I think he will make an excellent advocate for the states, even though in the future I would suggest that you temper down some of your rhetoric. You must was harsh. And I'm impressed with Ms. Sar's composure under the barrage of questions she received. I think that was excellent. Equally for the applicants, I think you were great. Your knowledge of the law was very good, and the way you applied it to the questions you were asked was great. And I just hope that you continue to be human rights advocates and not go into commercial law.
I hope they remember there is no money in human rights practice. Well, thank you. Justice, yeah? Today you are this.
Thank you. Thank you, and I'll just want to add on to what His Excellency Justice Fatou has said. Indeed, all the participants did great. From the applicants to the respondents, you did justice to the team. And I would want to encourage you to go back home as proud winners. You were all winners, despite we need to get one representative or one group to come out as winners, like as has been rightly mentioned earlier on. But just to make sure that you continue the path you've taken, that the human rights field needs you, the country needs you, and I'm sure the independent partners are there, the CSOs, the NGOs. When it comes to human rights, it's a whole field out there. And I just want to congratulate you once again and to say that you did great. You've tackled the issues, you responded persuasively, you've shown your comportment, the composure, you've really done great, and I think that's what we were expecting from all of you. So I would want to say big congrats to all of you, and to say that keep up the momentum. Thank you.
Thank you, Your Excellency. Justice Gomez.
Thank you very much, Mr. President. I am also equally very impressed with what I've seen and what I've heard. Your knowledge of the law, your presentation skills, to be honest, is very great. You guys have a long way to go. Apparently, you should be very confident of yourself that you have a great skill that you possess. So therefore, if you work on it and build on it, you definitely the sky is the limit. Just a quick observation is that in moot court, you want to avoid too much of opening statements, like 1 or 2, 3, 4, 5 minutes of opening statements. You have legal arguments to make, you have factual arguments to make. And also, if you're in a team of 2, there is only for 2 people to make 2 opening statements, for example. So someone makes an opening statement, the other one just want to come and proceed with the argument. So, but basically, that will be all for that part. I think also, again, don't be avoiding questions. Answer the questions as they are, no matter how less favorable they become. There's always one part, one team that will perhaps be at the disadvantageous end when it comes to the factum. So the judges may not necessarily, they don't score marks because they feel like you haven't really won your case in an actual real court setting. But they want to really know about your presentation skills, how you understand the law. So basically, actually, if you feel like a particular position of the law is or fact is not in your favor, what you want to do is, which judges are always interested in knowing, is your analytical skills. You always try to prefer another possible logical conclusion or explanation as to why the court should depart from one position and other. So always there has to be this logical explanation to events or facts or law as to why the court should. Not, you talk about standardized, for example, all of you argue standardized, why should the court not, why should the court depart from its earlier edition? You must have an explanation to that effect. And remember, it has to be a bit convincing. And one of the secrets is that if it's convincing to you, the likelihood it will be convincing to the other, to the judges as well. So therefore, in summary, you guys will...
Thank you. I have to, I think I'm the luckiest lawyer in the Gambia. On the bench, I taught 3 out of the 4 other judges. And when I look around the room, I think I taught more than 60–70% of everybody here. So that makes me very lucky. Yes, well, yeah, I'm getting there, but that's fine. I honestly struggle to, as in, place all 4, because You were all not good. You were all extremely, extremely good. It really wasn't about your knowledge of the law, particularly in international human rights law, not even the substantive bit, even procedure. What is persuasive, what is in. I really found that extremely, extremely good. And, you know, sometimes not just knowledge of the law isn't enough. You can know the law inside out, but you would struggle to articulate your views. That wasn't the issue here. So you were all very well spoken, very well calm, you know, missiles coming your way, but you were able to really make sure all of them were deflected. I wouldn't say we have a winner today, because all of you are winners, to be honest. And for someone like me whose area of practice is this part of the law, I really feel very encouraged when I see young people coming out, you know, saying, I want to be a human rights lawyer. You know, even though, like I said, you're not going to get briefs worth millions, but there is nothing more satisfying. So it really is good. So I think I speak on behalf of all the judges if I just say thank you to all of you for being here. Human Rights Commission, you are, we know, quite dynamic, you know, approaching human rights the proper way. The participants, everybody. So we're really grateful. By way of feedback, I know at the semi-final stage, this is something I think I talked about. Sorry if I have to repeat it. I know some of the counsel for the applicant respondent, you know, you would hear a lawyer say, we didn't have to exhaust local remedies because local remedies were not available, they were not sufficient, you know, they were not effective. And of course, they straight away would refer you to the Sardar, the Jawara case. But remember, you have just about 5–10 minutes. Time management is really of the essence. What I would please invite you to do, I mean, I heard one of them talking about reasonableness. It's okay to conclude that way, but it's also very important you back that up with facts and the law. Don't just say remedies available, you stop there. You really have to go on to demonstrate why you feel local remedies are not available. So it's really not just enough for you to say that, you know, and then refer us to a case. You really have to use your case to demonstrate why remedies are not available. So in other words, I'm just encouraging us to really speak to the issues. I mean, not that that's a problem. Like I said, you all did well. So now, with your permission, all of you, I have the honor to announce the final results. Like I said, we all struggle to have all of you placed. So I would start with the fourth position. Interestingly, no one got below 70. If you have 70, while I was at university, if you have 70, that was A. I'm not sure what it is here now, but 70 is definitely an A. So you all are 5-star students. All of you are A students. So I'm going to start with the fourth. We have place fourth, Miss Ami Kolesar, and she scored 70. Third, we have Kansel Omar Diba at 75. Second, we have Kansel Ebenezer Brown. And on top, he had 78, please, 78. And on top, we have Mr. Mohammed Sise. As the top counsel, I wanted to say congratulations to you and good luck. Thank you. The team, I'm reminded I should mention which team won. Team one, of course, is team one, as in the applicants. Yeah, but looking at the facts of this case, you would agree it wasn't easy for the state. The law wasn't on their side, the facts wasn't on their side. So I was really, really impressed by, the way you argued your case, even though you very well knew. So at least that just shows, your ability. It really shows how good you are, to be honest. So, but thank you. Like I said, you all are winners. The chairperson was the first Gambian to have a master's degree in international human rights law. So we are encouraging you. If you really need more guidance, you should feel free to knock on our doors. I'm sure the senior lawyers here with experience will be happy to guide you. So thank you all very much. Thank you.
Team 1, Mohamed Sise and Ebenezer Brown. And the runners-up are Ami Kolesar and Omar Diba. As indicated earlier on, the winners will be given a paid internship at the National Human Rights Commission. Now we've come to the handing over ceremony of the prizes and certificates. By way of information, 12 people have dropped out along the way and they are being certificated this afternoon. So let's give them a round of applause. Omar Diba.
Love like fire. Wow. Love like fire. Xam ngeen rek affaire bi xam ngeen fan la? Skincare la. 2020 lañ wax de. Waaw. Fii nag mooy Kerr fan Kerr zero tache. Perfect skin. Skincare saa su ne rek niñ ko dee defee rek. Loo lañ soxlaati rek. Maanaam bu dee am problème ci seen skin yéen xam ngeen fan la fii ngeen di ñëw suma xarit yeeg am di jàmm yi nga xam ne taas daf lañ sonaloon xam nga doon xeesal ba laka xum éneew ma lañ ko nag waaye just in case comme ni ko gars yi di waxee rek en cas just in case loolu xew xam ngeen fi ngeen di ñëw skincare plus si yu baax rek la ñoo dox nag ay baax rek fu ne la ñoo dem ci réew mi di lañ indi rek nag products yu baax du Paris du Italie du USA du fi mu nekk nii sax boole nañ ci nag Sweden fu nekk lañ leen a indilee products bu dee tamit nag da nga ñuul rek ñu lay jamaa natural beauty that melanin dripping we do have stuff for you as well emuñ si skincare products rek ñu ngi ci cuub yi tamit fu ne la ñoo jaar in fact sax last commercial bi ñu defoon waxuñ leen woon ne dañoo dox ci ay kawar 9A grade rek nag waaw we do have bundles as well hair si lu ne la ñoo dox ñun ñu ngi ci rafetal jigéen rek luy taaral jigéen rek waaw boo leen di tukki tamit bëggoon rek classic suitcase ñu dañoo dox ci ay Samsonite duñ dee indi any brand of suitcases though other than Samsonite comme li ma dee wax rek boo eggee airport dëri Samsonite dafa am nuñ laa xoolee waaw ngeen ne lan nag waaw skin ci moom la ñu gën a xamee nag skin care products ci moom la ñu gën a xamee ñu ngi dox tamit bentee tamit si ay dàlla man waaye man nag skin care mooy suma specialty xam nga rek jigéen bu sa xar kanam réglé loo def mu jag am nañ Patricia Reiner Kiwi Eye the whole range Lighten Up Gold Tomatine I mean the list can just go on and on and on and on lépp loo xam ne rek luy taaral jigéen la ci yooyu rek la ñoo dox skin care plus nag emuñ si Gambia rek ñu nga United States ñu ngi Gambia fii ba pare bu dee yaa ngi anywhere in Europe mun nañ la ko mail within 3 days rek ñetti fan rek nga jot say diw emuñ si loolu rek dañ laa consult tamit balaa ñu laa jaay diw dinañ def a free consultation pour wax la rek exactly li nga xam ne moo méngoo ak sa kanam dinañ leen wax tamit ne rek am nañ perfumes fragrances men's shirts accessories we do dresses as well we do blouses I mean we do shoes name it we do them Skincare Plus 2020 is our year of perfection zero task fi mu nekk nii réew mi fii kenn waratu fi task kenn waratu fi am problème kanam kenn waratu fi am problème yi picca boo ko amee dafa fekk ne rek ñëwuloo ci place bi fii
love like fire bring my yobo gumba fire love like fire
Agada.
Mbijan aganyadi.
Albaka.
Mbaka important.
Yo, nga transfer la sto.
Ya transfer la sto.
Ha, code nyenje.
Okay. What's Nsila ID soto.
Ah, sa soto. Sorry. Agada.
Mbijan bro.
Albaka.
Mbaka.
Bara alla service o tariaka.
Ah,
mbale. Mo ki janna nun kunu bara tariaka.
Ah, jannom yona forest de bureau. Gambia tonkon na no mbali ya bere. Ha. Birim koyna fo katon
bari si kodo kino katon ni fo bolon blabe
56 branches mola soto Gambia jam
ha
Gambia kono ani Gambia bantala bankol nka kodo kiya bele kodo sifa fo falindiro fo nyaadi lafta memmen na kodi topoto nin kodi maraw jannom number 1 ti nyonta andum fana nata anoda enterprise sotale wolam nyindi ko domorol fana kol fana be firale de dadi mani domorol dir fana beteata Gambia dawda yalo ngam fa kendol sotale je
wo moyo diat
apelenta
baraka ba ya lafta nyelan kendol e bina
yalo bu kanila ko la baraka ba
yalo ndel ciosano lo
baraka
We live in a day and age where technology is creating a world without borders, filled with unlimited potential to improve the lives of the people around us. Innovarex Global Health ushers in a new way of leveling the playing field with increased access to quality healthcare services delivered at your doorstep. Our qualified professionals are equipped with state-of-the-art point-of-care testing technology to conduct tests such as kidney function, liver function, electrolyte tests, body composition, hemoglobin, A1C, and many more services with the highest efficiency in delivering results. The addition to our flagship Wellness on Wheels, more fondly known as WOW Delivery Service, brings the entire clinical experience full circle. IGH has remained committed to creating the future of healthcare delivery. Gone are the days of sending loved ones outside the country for basic medical services. Innovarex Global Health offers a new peace of mind and takes pride in delivering the quality of care we all deserve.